Imagine you're cruising home. It's a quiet evening. Suddenly, those strobing red and blue lights fill your cabin. Your pulse spikes. An officer approaches, and his very first question is a calculated legal trap. What you choose to say in the following 10 seconds will dictate your entire future. Every single day, thousands of motorists make a catastrophic error. They believe that being helpful or talkative will grant them leniency. But the American legal system doesn't reward cooperation. It rewards those who understand their constitutional boundaries and know exactly when to stop speaking. I've analyzed hundreds of roadside encounters and dissected landmark Supreme Court rulings. I've isolated 4 specific verbal shields, 4 exact phrases, that can terminate a traffic stop in less than 2 minutes. Deploy these 4 lines and you remain legally untouchable. Neglect even one, and you've essentially handed the police a blank check to search your vehicle and use your own words to build a case against you. Let's dismantle the 4 most common traps and the 4 precise phrases that keep you protected. Mistake number 1. Falling for the confession hook. The officer leans in with a friendly tone and asks, "Do you have any idea why I flagged you down?" Most drivers, wanting to appear transparent, start speculating. They say, "I might have been pushing the limit a bit," or "Was my registration expired?" You've just signed your own conviction on a high-definition body camera before the officer even stated his observation. Here is the legal reality. Salinas versus Texas, 2013. The court made it clear that you must explicitly claim your protections. If you start guessing, you've effectively waived your rights. Your speculation becomes admissible evidence. The prosecutor doesn't even need radar data because the body cam footage shows you admitting to a violation. The correct move. Line 1. I prefer not to speculate, officer. Stay composed and professional. Just say, I prefer not to speculate. You aren't being evasive, you're being legally precise. This forces the officer to put his reasoning on the record first. You haven't conceded a single point, keeping your defense intact while remaining completely civil. Mistake number 2, granting blanket consent for searches. The officer hands you a warning and the stop seems to be winding down. Then, he drops the bait. You don't mind if I take a quick look inside the vehicle, do you? Most people panic. They think, if I refuse, I'll look like I'm hiding something. So they say, go ahead, I've got nothing to hide. That one sentence just dismantled your Fourth Amendment protections. Understand this. If an officer had the legal authority to search your car, he wouldn't be asking for your permission. He would be ordering you out. When an officer asks for consent, it's because he lacks probable cause. He is fishing for a reason to arrest you, and you're handing him the hook. The moment you agree, the search is legal. They can dismantle your interior, check your trunk, and if they find anything, even a misplaced prescription, you're the one in handcuffs. The correct move. Line 2. I am withholding consent for any searches. State it firmly and clearly. I am withholding consent for any searches. If he persists, do not argue. Just repeat the phrase. This shifts the entire legal burden back onto the officer. If he proceeds anyway, he must justify it in court later. And since you denied consent on video, your attorney has the grounds to get that evidence suppressed. Mistake number 3, lingering in legal limbo. The ticket has been issued. You've signed the paperwork. Yet the officer remains at your window, chatting about your destination or your day. You stay there because he's still standing there. But every minute you spend answering casual questions is a minute you are voluntarily prolonging your own detention. In Rodriguez versus United States, 2015, the Supreme Court ruled that police cannot extend a traffic stop longer than necessary to complete the initial task. Once that ticket is handed over, the legal clock should stop. If he keeps you there without new, specific evidence of a crime, that is an unconstitutional detention. The correct move. Line 3. Is this encounter concluded or am I being detained? This forces the officer to make a choice. If he says you are free to go, depart immediately. If he says no, he is now legally required to have reasonable suspicion to keep you there. You've just forced him to justify his actions on camera, which is a powerful deterrent against harassment. Mistake number 4. Assuming silence is an automatic shield.
If
The
my
officer
license plate
asks a
expired
probing
today, I
question
have
like,
until
"Have
tomorrow
you
to
been
get a
drinking
license
tonight?"
plate, right?
We're gonna get in the car.
You
Okay?
decide to stay quiet,
All right,
thinking the
in
Fifth
the car.
Amendment has your back automatically. But under Salinas versus Texas, mere silence can be used as consciousness of guilt. In court, a prosecutor will tell the jury, "Notice how he didn't deny it. An innocent person would have said no." Juries find silence suspicious unless you explain the legal reason behind it, the correct move. Line 4, I am invoking my right to remain silent. You must vocalize your intent. By saying, "I am invoking my right to remain silent," your silence becomes a constitutionally protected act. It can no longer be used as evidence against you. You've drawn a line that the prosecution cannot cross. At this point, stop talking entirely. A traffic stop is a formal legal investigation, not a chat with a neighbor. The law protects the informed, not the talkative. Let's recap your 4 verbal shields. 1. I prefer not to speculate, officer. 2. I am withholding consent for any searches. 3. Is this encounter concluded or am I being detained? 4. I am invoking my right to remain silent. Memorize these, keep them in your visor. Adrenaline will try to take over, but these phrases must be your automatic response. Stay informed, stay shielded, and always protect your constitutional rights.